Today at the National Press Club, the President of the Australian Human Rights Commission, Rosalind Croucher. The Emeritus Professor believes Australia has a once-in-a-generation opportunity to create a National Human Rights Act to protect all Australians' fundamental rights and dignities. Rosalind Croucher with today's National Press Club address.
Good afternoon, ladies and gentlemen, and welcome to the National Press Club and the Westpac Address, where we are coming to you from Ngunnawal and Ngambri country, Canberra. My name's Laura Tingle, I'm the club's president. Human rights and the right to live without facing discrimination because of our ethnicity, age, sex or disability should be something, and maybe often are, taken for granted. But so many of our policy debates in recent years have focused on the shortcomings of protections for different groups in the community. What to do about this? Our speaker today approaches the topic from a long history in legal studies and law reform, and from a long period now as the President of the Human Rights Commission. Please welcome the President of the Australian Human Rights Commission, Emeritus Professor Rosalind Croucher, to address us.
Thank you, Laura. And thank you to the National Press Club for giving me this opportunity. I would like to begin by acknowledging the traditional custodians of the land on which we are meeting today and pay my respects to elders past, present and emerging, and to any First Nations people attending in person or watching today's broadcast. Commissioner colleagues, senior staff of the Commission, Commission EAs, colleagues from the Attorney-General's Department, my husband, Emeritus Professor John Croucher, friends and colleagues. I speak to you today in the final weeks of my 7-year term as President of the Australian Human Rights Commission. When I began my term in 2017, the marriage equality plebiscite was engulfing our nation in much the same way as the recent Voice referendum did. Although the outcomes were different, the focus on human rights which framed the respective debates serves to remind us that the application and experience of human rights are elemental in the way we function as a society. As I conclude my term as President, the war in Gaza is inflaming tensions across our country and having terrible impacts on our Jewish, Palestinian, Muslim and Arab communities. And at the same time, complex issues such as domestic and family violence, child justice, immigration, housing, the environment and climate change, among others, continue to torment and frustrate many people and communities. With a population as diverse as contemporary Australia, there will always be intersections and indeed friction between people who fail to take the time to understand or care about the welfare of others, or who believe their rights or their idea of their rights should prevail over the rights of others. Whenever we deny the rights of others through action or inaction, we deny ourselves one of the best and most important parts of what it means to be human. Having the capacity to feel empathy and practice respect. These values form the glue which binds us together, allowing us to fathom the dreams and nightmares of others, and then use that understanding to live together free and equal in dignity and rights, as famously expressed in the Universal Declaration of Human Rights. If we are to live the values of human rights that are fundamental to the healthy functioning of our community and democracy, we must all ensure the actions we undertake and the language we use to advocate for the rights of some do not undermine the rights of others. This is the reasoning and sentiment that should guide all of us, even in the worst of times, that human rights exist to protect everyone, everywhere, every day. By having empathy and compassion, and by making dignity real for everyone by respecting each other, we keep true to our shared humanity and to the best part of ourselves. My commitment to these values has framed not only my time at the Human Rights Commission, but my 10 years prior as Commissioner and then President of the Australian Law Reform Commission. This equates to nearly 18 years in roles which seek to progress law reform and to positively improve social justice for all Australians, a contribution to Australia's public life that I have been honoured to make. Today, I want to reflect on and celebrate the role and work of the Australian Human Rights Commission. And I particularly want to send a clarion call to action for all Australians. The Australian Human Rights Commission is an iconic institution in our democracy. It is one of a suite of small but mighty agencies which hold government to account and which protect the rights of the public, regardless of the political tides of the day. Our functions are conferred on the President and Commissioner Group, independent of government control. We are not constrained to act in accordance with government policies or agendas. We are here to push governments to do more, to do it better, and to be answerable for their decisions. We are one of democracy's accountability mechanisms. And so, at times, we may be unpopular with either the government or the opposition of the day for how we go about our work. Our work is enduring and must have significance beyond political cycles. The role of the Human Rights Commission, the Law Reform Commission, and other such agencies is important for present and future Australians, for our children and our children's children, as I will return to at the end of my speech. Our concerns are not limited to what the government of the day wants Australia to be. We are focused on what Australia should be. Sometimes reforms we propose may come immediately, such as the recommendations from the Commission's landmark Respect at Work report about addressing sexual harassment and inappropriate conduct in workplaces. Sometimes it takes upward of a generation. As an example, one of the Commission's most iconic pieces of work is the Bringing Them Home report about the forced separation of First Nations children from their families. The report was released in 1997, but it was not until 2021 that the Commonwealth, under Prime Minister Morrison, implemented a key recommendation for financial compensation. It is a good example of what I call the long arc of law reform and of a commission pushing government to do more and to do better. There are many other such examples. The reform of hundreds of federal laws to remove same-sex discrimination after a national inquiry by the Commission in 2007. The work of successive disability discrimination commissioners that mean you can take prams on buses, trains and trams. And the Closing the Gap approach to improving the health and well-being of First Nations people, which was designed by the Commission, opposed by the government of the day, and is now orthodox policy. mighty indeed. And there are literally thousands upon thousands of stories of how our complaints handling work under discrimination laws changes people's lives on almost a daily basis. It is a wondrous organisation, full of extraordinary, largely unsung people. However, this wonder is, for me, tempered by one of the most surprising aspects of leading the Commission. That despite our role being clearly and expressly laid out in legislation, it is often willfully or otherwise misunderstood. Commonly expressed canards about the Commission include references to people being hauled before the Commission, disappointment being expressed when we don't prosecute someone, and the very generalised criticism about being absent in commenting on an issue, usually at a global or international level, and usually expressed as, "Where is the Human Rights Commission?" These critiques and critics misunderstand several key parameters. That we are obliged to consider all complaints that are sent to us, that no one is hauled before us. We provide a dispute resolution process that is neutral, voluntary and low cost. And fewer than 4% of the thousands of matters conciliated every year by us go anywhere near a court. That the accepting of a complaint does not automatically mean that the Commission considers it to have merit. That we have no power to prosecute anyone and do not instigate complaints ourselves. And that our role is about human rights issues in Australia. We are not a public commentator at large on the state of the world. But enough of that. The key focus of my speech today is under the banner of Free and Equal, which is the title of a major national reform project that I have overseen during my time at the Commission. Over 5 years, we have undertaken national consultations, 2 major conferences, and multiple technical workshops. And we have released issues papers, discussion papers, 2 major position papers, culminating in a final report tabled just in time for International Human Rights Day, the 10th of December last year. The final report is titled Revitalising Australia's Commitment to Human Rights, and it provides a comprehensive set of recommendations to improve the protection of human rights in Australia. This is the clarion call to which I referred. Today, my simple message is that the Australian government can do better to protect people's rights in Australia. We have lost our way at the national level over the last 15 years or so, and we are in need of significant action by our government to fix this. Firstly, our discrimination laws are out of date, confusing, and do not serve Australia's needs in the 21st century. They are framed in the negative, telling us what we can't do rather than what we can do. And they are largely reactive, which means there are limited obligations to stop discrimination from occurring in the first place. Secondly, we lack basic accountability to Parliament and to the Australian people for how we protect human rights. Thirdly, we have a significant lack of public education about our rights. Respect and dignity and the human rights that reflect this should be a foundational element of our civics education and core to the maintenance and progress of social cohesion. Fourthly, we lack basic, measurable data against which to track how we are progressing. Governments are here to serve the community, and yet we lack basic tools to measure whether we are advancing or regressing on key measures of well-being and whether the opportunity to thrive is afforded to all in our community or just some. But most fundamentally, we lack basic protections of human rights. We saw this in graphic detail in royal commissions into violence and abuse against people with disability, the treatment of our veterans and people in aged care, and in the scandalous robo-debt scheme, where the rights of the most vulnerable of Australians were flagrantly disregarded. As we leave the COVID-19 pandemic in the rearview mirror, as we contemplate the challenges of climate change into the future, and as we consider the social justice implications of cost of living pressures, it is time for better protection of human rights to be a central consideration by our Parliament and by our government. If we do value fairness, if we do value dignity, if we do care about equality of opportunity in this country, then we need this foundation of human rights to be embedded and strengthened for all. The centrepiece of our National Human Rights Reform agenda is a National Human Rights Act. This would operate in the following ways. First, Parliament would consider more directly how their lawmaking affects people's freedoms and rights, and more robust scrutiny processes of the Parliament would require intense focus on whether laws breach rights, whether this is appropriate, and whether there are better alternatives. Second, where laws and policies affect discrete groups, such as First Nations people or people with disability, a Human Rights Act would require that their views have been sought and fully considered. And government would be accountable for how they sought such engagement and what they did in response to it. This goes to a fundamental problem in law and policy making in Australia, a lack of participation by affected communities. Third, a Human Rights Act would create clear expectations for public officials who would be duty-bound to fully consider human rights impacts and who would be accountable for how they do this. Robo-debt is a perfect example of a failure to do this, and where the potential for that scheme to egregiously affect people was willfully ignored. Fourth, a Human Rights Act would set out what rights in the community everyone should enjoy. Supplemented with education and other support, this builds a culture of rights awareness, what I've called rights-mindedness. The importance of this cannot be overstated. If you approach the task of designing laws and policies with the lens of how will this advance people's rights, or how do I ensure that this law does the least harm to members of our community, it will inevitably result in better decisions and better outcomes. And if all else fails, the Human Rights Act provides a remedial framework to administrative review and ultimately the courts. This is important. While the majority of action under a Human Rights Act would not take place in the courts, there has to be the possibility that this could occur for the Human Rights Act to have impact, to give the leverage that is needed in the upstream. So a Human Rights Act has a role to play in all three branches of government. It improves the focus of Parliament in their lawmaking role. It builds rights-mindedness among public officials and the executive government, and it enhances the scrutiny role of the courts to ensure that decisions are made lawfully. Over the course of the past 7 years, I've become increasingly convinced of the central importance of a Human Rights Act in our democracy. Why? There are many reasons. The first is that we lack our own Australian language for talking about rights, and we see this in the lack of civility in many public debates at present. Much of the terminology and discourse around rights in our country comes from international treaties and conventions. And as long as the universal human rights to which we are all entitled remain referenced in foreign contexts, there will be resistance to their embrace by some in Australia. A Human Rights Act would place rights at the forefront of our thinking about policies and laws. Respect, dignity, fairness and equality would be central considerations, not just an afterthought. It is time to bring rights home and to own them as a reflection of Australian values and our government's promises to the world about the standards it will uphold for people in Australia. The second reason I want a Human Rights Act is because I have seen how ineffective our current system is for protecting human rights in Australia. This was clear during the COVID-19 pandemic. The Commission received hundreds of complaints from Australians locked out of their country. We heard heartbreaking stories of people separated from dying relatives, in need of urgent medical assistance in Australia, who could not get any engagement from their government to consider their personal situation. The existing legal protections were ineffective and basically disregarded by the government. For a country that prides itself on the fair go, which values decency and dignity, it is troubling that we don't give meaning to our long-held values in our national legal framework. Many of the things we say we value are not, in fact, protected adequately in Australian law. These include freedom of expression, freedom of movement and the right to protest, freedom to live in accordance with one's own beliefs and values, the right to essential standards for a dignified life, such as access to basic healthcare, housing, education, a healthy environment and work, as well as protections against homelessness, hunger and poor working conditions. There is, however, a state of denial by some about this lack of protection. At the Commission's recent National Conference on Human Rights, Professor George Williams described this denial as akin to walking into a thunderstorm without an umbrella. No more pretending, please. The third reason we need such protection is to build that culture of rights-mindedness within Parliament and government and across the public sector. This is the greatest impact that a Human Rights Act will have for Australia. A Human Rights Act is not a revolutionary proposal. There is nothing exceptional about the idea that when making laws or taking actions or decisions under them, that parliamentarians and public officials should consider the impact of their actions in relation to humans and their rights. Nor is it exceptional that they should favour options which positively protect people's human rights or minimise the harm caused to them. And there is nothing new in the idea that if people's rights are breached, they should have access to effective remedies. Where the main action takes place is the cultural change that a Human Rights Act will bring to Australia. As an analogy, we don't want people driving while drunk or on drugs, but we wouldn't leave it up to people's common sense not to drive while intoxicated. The possibility that if you do drive while under the influence, you will be fined, receive demerit points or lose your right to drive has been proven to result in more effective road safety. Some people still breach laws, but the main impact comes from the setting and understanding of a community standard and the expectation of how you will interact with your fellow citizens. Ultimately, we need better human rights protections in Australia because everybody's human rights matter all of the time. Speaking at the Commission's recent Free and Equal conference, Rob Hulls, the instigator of the Victorian Charter of Rights and Responsibilities, reflected on its impact. He spoke of some of the best achievements of that legislation being simple outcomes for people who were otherwise failed or were invisible to government. Outcomes such as getting a shower curtain installed for a woman in aged care to protect her privacy, or ensuring family can stay connected to people in aged care during the pandemic. Seemingly small outcomes to you or me, but ones that make a substantial difference to the lives of those individuals affected. A National Human Rights Act will give similar protections in interactions with the national government. It will protect women exiting a violent relationship in their interactions with Centrelink about social security. It will protect veterans at risk of homelessness and struggling with mental health issues. It will protect people being mistreated in aged care facilities or subject to unreasonable restrictions on their movement. There is no sound basis for denying such protections any longer. Let's protect people's rights instead of having another generation of royal commissions forensically examining the damage we inflicted on people by not respecting their rights in the first place. There can be no doubt that successive Australian governments have failed to protect all people in this country because of a lack of protection of human rights. The time for action is long overdue. And here is the best bit. There is nothing abstract about my call to action for better human rights in Australia. The government right now has before it 4 things. First, the Commission's Free and Equal report, detailing all the proposed elements of a new national human rights framework and how it could be implemented. Second, 2 position papers setting out an entire national discrimination law reform agenda and a model human rights act. Third, the recent final report of the Parliamentary Joint Committee on Human Rights from its independent inquiry into Australia's human rights framework, which provides a ringing endorsement of the Commission's reform agenda. And fourth, the final report of the Disability Royal Commission, which also endorses our proposed reforms. In other words, every step the government should take to better protect human rights is laid out in precise detail in these reports, all of which have been released during this term of government. The hard thinking has been done. The design work has been done. These proposals have also been tested through extensive public consultation processes. What a gift to the Parliament, to the government and to the people of Australia. A roadmap for significant reform is sitting on a silver platter, ready to go. So no excuses, no reason for dithering. The time for action is now. To conclude, I would like to bring us all back to the Universal Declaration of Human Rights, truly one of the great documents about human rights aspiration and endeavour. Its preamble speaks of reinforcing faith in fundamental human rights, in the dignity and worth of the human person, and in the equal rights of all people to promote social progress and better standards of life in larger freedom. That is what proper protection of human rights means. I am proud that the small but mighty Australian Human Rights Commission, as Australia's national human rights institution, has played its part in identifying this generational reform agenda for government. We stand on the shoulders of many who have come before us, and it is a legacy of work that I am proud of in pursuit of larger freedom for the generations to come. In speaking of our children and our children's children at the beginning of my speech, I referenced the last stanza of a poem by Indigenous poet Udjuru Nunukul, A Song of Hope, that I was introduced to by former Social Justice Commissioner Mick Gooda. And it is with Udjuru's fine words that I would like to conclude my address today. To our fathers' fathers, the pain, the sorrow. To our children's children, the glad tomorrow. Thank you.
Thank you so much. It opens up this huge box of ideas and questions. I suppose I've never actually thought about it. Essentially, the human rights framework in Australia is essentially been based on the powers of the Commission in a way to intervene. So what I'd be curious about would be how the Human Rights Act, as implemented, would affect other legislation. Would it be that over time legislation would have to have a specific human rights acknowledgement, or, you know, as is often the case with legislation, whether it's in the cabinet process or in the explanatory memorandum or whatever, there'd have to be a box-ticking exercise to say, well, we have actually thought about these things, and new legislation would have an explicit human rights aspect to it. How would all of that work?
At the moment, when new legislation is proposed, it has to have with it a statement of compatibility against the international treaties, which is one piece of consideration for human rights that has survived from 2009 in the work that Father Frank Brennan led in that enormous national consultation. The problem, though, is it's still referencing the foreign stuff, and it provides an opportunity for distancing as the political will or the tide of the moment takes it on a particular day. The difference in bringing those rights into Australian law means that the consideration of rights is not foreign stuff, it's rather our stuff. And it's a reflection of the promises that our governments over the years have made to the world, that they will bring those obligations as real obligations into our own laws. And that would be the difference. It would make the engagement with human rights a serious undertaking, not, as the phrase you used, Laura, was a box-ticking exercise. It would make it meaningful, and it would be anchored in our laws.
So, but just to clarify, though, it wouldn't necessarily mean that there would be specific sort of clauses put into pieces of legislation, but there would be just the general reference that it would have to be compatible with our Human Rights Act, which, as you say, would be brought back home rather than being based on international obligations.
I would say it's not about a statement, but rather a process. And it's the process of legislative design, policy design, that anchored in this culture of rights-mindedness framed through the lens of human rights. Does this serve a legitimate outcome? Is this the least restrictive and for the shortest time possible? That will become an automatic reflex in thinking when it's placed as an obligation from the moment that the idea for a policy or a law comes up.
Paul Karp has a question.
Paul Karp from The Guardian, thanks very much for your speech. The Albanese government wants bipartisanship before it introduces or even releases its religious discrimination bill, which is obviously a bill that engages the right of non-discrimination. Could I please ask, firstly, do you regard that bill as urgent? And more broadly, secondly, should it be necessary for both sides of politics to agree on a new form of human rights protection, like the Religious Discrimination Bill or the Human Rights Act that you've advocated in your speech? Should bipartisanship be necessary before an attempt is even made to improve the human rights framework?
Thank you, Paul. If I start with the question which was focused on religious discrimination reform, the Commission has advocated for a very long time that protection for discrimination on the basis of religion needs to be brought properly within the suite of discrimination laws in line with the Sex, Age, Disability and Racial Discrimination Acts. We have also advocated for a long time that there needs proper protection for religious freedom. The challenge is when the two issues become intermingled, where they are distinct issues, and the other element that needs to be untangled from all of that is the amendment to the Sex Discrimination Act, again, which the Commission has advocated for a long time, which was the provision in relation particularly to religious schools, and that the issue of religious discrimination and protection for religious freedom needs to be considered properly. There have been commitments by both governments in terms of religious discrimination, but clarity on the issues, the gaps in the protections of our laws, that needs to be the priority in human rights terms.
And more broadly, do you think it's better to have bipartisanship before even putting these up, or should governments seize opportunities where they exist to improve the human rights framework? Would you be happy to have your bill stalled if one side of politics wanted to do it and the other didn't? Politics
is always a deal. In any government, the introduction of legislation is a matter for the politics of the day. What I can say is that the commitment by our governments over the years, whether it's a coalition government or a Labor government, they have agreed in equal measure in signing up to international treaties. It should not be a party political issue whether we bring human rights promises in terms of protections into our own legal system.
Melissa Code has a question.
Hi, Professor Croucher. Thank you so much for your talk and all your work and the work of the people in the room. It does sound like the Commission does a tremendous amount of things on the smell of an oily rag. My question is about how the proposed Human Rights Act can bolster the work of public servants. And obviously, they currently operate under a system and with an ecosystem of scrutiny and accountability already. They have values and things they must adhere to make sure they're adequately consulting with community when policies are lifted off the ground. Why do you think it is we must have a Human Rights Act to enliven this culture of rights-mindedness you describe? Cannot that exist without a Human Rights Act?
I should start by saying I have great respect for our public officials. Having worked in my role for nearly 18 years, I have worked closely with departmental officers and others and have deep respect for the responsibilities that they carry. The idea of rights-mindedness of which I have spoken is about providing support for the great work that our public officers do, our public sector officials. It provides the backbone that they can use as their tools in their leverage, in their own advocacy, in their relationship with their relevant ministers. It would reinforce their ability to do so. And quite frankly, the unifying theme in all of those Royal Commission reports, which were very compelling reading in terms of all of those who were invisible before, the one linking theme is a change in culture. But that doesn't mean that the commitment to the ideas is not there. But what is needed is greater capacity, greater tools, greater support, framed through the language and strength that a Human Rights Act can provide to our great public service.
One of the things you passionately spoke to in your speech today was a need for Australia to develop its own language around human rights and you know, to avoid this misconception that human rights is an international notion that belongs elsewhere. Recently at your Free and Equal conference in Sydney, great legal mind Kate Eastman was talking about the need for a total reset of the way we approach human rights in Australia, essentially requiring a conversation about reimagining the shape and form of the Commission. What are your views on that? Do you have any salient things to say perhaps to your predecessor about having an appetite for reimagining what the Commission is and does, in particular the way in which intersectional issues are adequately addressed, having discrete commissioners for community group X or Y?
To my predecessor or my successor? Yes. The design of a statutory institute, we are a creature of statute. And as we are a creature of statute, we show all of the barnacles of our history. And partly the way that the Commission has developed over the years has been when another international treaty has been adopted by our parliaments. And the difficulty with we adopt a treaty, we introduce a discrimination law, and we add an extra commissioner on to the Human Rights Commission. And then we add in a National Children's Commissioner and a Social Justice Commissioner to look at the issues of intersectional relevance, particularly through the lens of children and young people and through the lens of First Nations people. It's an untidy structure, something I have spoken about before, but it is the structure we have. And as a small but mighty agency, we use the distinct special purpose commissioner roles for very distinct advocacy in relation to those sectors. And when there's been discussion in the past about maybe blending commissioner roles or taking some away, what's been very interesting is to see the outcry from the communities who feel, why are you taking our commissioner away? There is a sense of owning, because that's the only way we protect human rights in Australia at the moment. It's through the lens of these discrete areas under the discrimination laws. So one can design everything differently. I've often had moments that I've spoken about with secretaries over the years, and I'm up to my 4th secretary and 8th Attorney General, that if we had a whiteboard, we could design things differently. But the practical reality is we don't. And given that we don't, we are very open to all the conversations about it, so long as it enables us to do our work better, makes us stronger and makes us mightier than we are mighty already.
So just taking that up, in some ways it sort of suggests that there'd be more stability in our own sense of what our human rights obligations were if we were drawing up ourselves, rather than sort of randomly having them sort of fly in from overseas. But it does raise the question of how, I mean, is that right, that it would be a more stable sense of rights that were based in the sorts of discussions and issues that take place in Australia? But what do you then do about those, occasional turn-ups from international bodies about obligations at the UN level?
It would build the generational shift, I think, Laura, to enable those conversations. I often use the example of the eldest of my grandchildren spotting a copy of the Magna Carta on my wall in my study. A beautiful 13th century document in medieval Latin. I would far rather have a conversation with my grandchildren in Australian terms, referencing hand on heart Australian law, than the Magna Carta, which he learned about through horrible histories. We need our own history and our own commitment to rights in Australian law.
You also spoke about the long arc of law reform, referencing a 1997 report, one of the recommendations of which was recently brought to life. What are your views on political appetite for change? I'm thinking about Michael Kirby chastising Josh Burns about there not being enough bipartisan support about the Human Rights Act reforms. Is it okay for us to wait another time period equivalent from 1997 to 2000 and whatever for these reforms to finally take life?
I would prefer that I'm not talking to my great-grandchildren about this subject. What we have at the moment is an alignment of great pieces of work. You know, this is not the Human Rights Commission sitting alone. This is the Human Rights Commission, the Parliamentary Joint Committee on Human Rights, the Disability Royal Commission, the other Royal Commissions that have said we need to change. We've provided a roadmap for change, and I would sincerely hope, I am a believer in the long arc of law reform. I haven't been doing this, I've been doing this now for nearly 20 years. I do believe in the long arc of law reform, so long as all of the reforms that you recommend are principled, well-researched and have the evidence base to support them. Then the moment has to take its place in the political cycle. I'm a realist there, but I think we have the wind in the sails of possibility right now, and I sincerely hope that in leaving this office, it is not a conversation I have to wait to have with my great-grandchildren.
Nick Stewart.
Thank you very much. You've served up a beautiful platter of reform for the government, and they apparently find it somewhat indigestible. I'm wondering, next week we have the Attorney-General here. Would you like to see him commit to actually introducing at least the, if not the final bill, at least beginning the conversation about it in this term of Parliament, actually getting a date so that in this term of Parliament the government will act towards trying to create a human rights bill? Secondly, that first of all.
Yes, better to keep one question at a time. It's not for me to set agendas for the Attorney. The Attorney committed to the process by getting the Parliamentary Joint Committee to consider a human rights framework for Australia. He's initiated that action. He has their report. So his commitment to the idea of changing, modernising, providing a human rights framework for today's Australia is real. Now he has the series of reports, as I said, not flippantly, but seriously, on a silver platter, or at least on his desk. He has those reports. There are other issues. The religious discrimination issue is obviously a live issue. There are other commitments that the government has made, including the amendment to the Sex Discrimination Act as a priority. There are many issues. In terms of the what next, that is for him. He has this body of work. And what I would like to see as the next step is the introduction of an exposure, or the development and introduction of an exposure draft bill based on the model that was used as the centrepiece in the report of the Parliamentary Joint Committee, and open it up through that vehicle, the further consultation and engagement which people want to have, but on an exposure draft bill. That's what I would like to see. And you can ask the Attorney, throw him the challenges that you would like to make, but it is now up to him.
If we had an effective Human Rights Act, would we necessarily need a Religious Discrimination Act?
They are distinct ideas. The idea of a Religious Discrimination Act is distilling the rather archaic protection we have at the moment in terms of discrimination on the basis of religion in the area of employment, to making that a proper protection against discrimination on the basis of religion in public life, which would make it in line with the other 4 discrimination laws. It is a gap, and we've advocated for that, but that's all it should be. The protection for religion to exercise one's beliefs or no beliefs is another fundamental aspect of the International Covenant on Civil and Political Rights and is worthy of its own protection, and it looks at issues through a different lens. You
referenced, finally, robo-debt. And of course, as is quite famous, nothing has been, no recommendations have been pursued in terms of putting anyone in front of the courts. If there was a Human Rights Act, would you see that as raising the potential a cause of action for such a prosecution?
What it would do is provide to individuals a pathway to effective remedy. I mean, this is, of course, after the fact. What we would hope is that the policy design and laws would be designed much better and acutely focused on the impact that they're likely to have. What ministers do, quite frankly, is their problem. But in terms of the design and the structure, the responsibility of Parliament in terms of reviewing proposed laws would be much sharper. But what would also be there is the right to effective remedy. The remedies that were pursued through administrative review didn't really go anywhere and show the impotence, if you like, of the existing remedial framework in relation to those kinds of abuses.
Paul Carp.
Thanks.
Back again.
Thanks again, yes. The Human Rights Commission intervened in the NZYQ High Court case on the legality of indefinite immigration detention, but it appears to have sat out the current case on the legality of ankle bracelets and curfews imposed on those released from immigration detention. Can I please confirm that you're not intervening in that case, and if not, why not?
The decision to intervene is one that we exercise very carefully. If we intervened in every potential case that raised all sorts of issues, that would be all we do, Paul. We do a lot of other stuff. Small, mighty, yes, but small. And over the years, we've intervened in 80-plus cases, and this goes back to 1981 when we were first set up, but from 1986 as well. So we choose carefully the fora in which we will engage. The NZYQ case, and just in terms of what it was ultimately about, and the human rights issue that has been one that we have been acutely interested in not only ever since, but we were in the Al-Kateb case 20 years ago. The human rights issue that we were tackling was the right of a minister, essentially, by executive fiat, to keep someone indefinitely detained administratively. Not courts making a decision about punishment, but an administrative decision where someone could be in detention indefinitely. That is the arbitrary detention element that we have constantly attacked, and any opportunity to intervene in relation to such a matter, bringing the lens of human rights, and particularly the framing of arbitrary detention, into a consideration, that has been our focus. And so with the NZYQ case, in the limited role, we are not a party, in the limited role that we play in such matters was again to bring to the forefront the profound inconsistency and the great difficulty to any right-minded person that somehow indefinite detention at the whim of a minister was okay.
Does imposition of conditions on non-citizens released from immigration detention that are not imposed on Australian citizens who've been convicted of a crime and served their custodial sentence, doesn't that raise human rights concerns about the right to non-discrimination, that non-citizens are treated differently?
Yes, it does. And
but not sufficient to intervene in that case.
Can I just check we're not intervening in that one? No, we're not intervening in that one. I have to check my facts on that one. Where we do intervene, Paul, is in terms of the parliamentary processes when the legislation was being proposed to introduce the frameworks. We have been an active participant in making submissions, drawing attention to the discriminatory or unevenness of those constraints, and advocating for using, particularly when people have been convicted of a crime and they've done their time. Under our current criminal justice system, there are circumstances in which a court may grant an extended supervision order in appropriate cases. So we have mechanisms within our criminal justice system for keeping people who may pose a threat to the community. We have mechanisms for keeping people under the watchful eye of our criminal authorities. Where we would have a problem is when suddenly whole cohorts of people are suddenly treated as somehow evil or requiring lesser protection than criminals who have served their time, done their crime and served the time, and are then in community and treated through extra vigilance, through extended supervision orders or otherwise. Our problem is when it is discriminatory, targeting a particular cohort. The danger to the community is something that our criminal justice system always has strongly in mind and should be in mind in relation to any cohort of people, whether it's people who have been released from immigration detention or released from prison. The security of and the safety of the community is a paramount concern. The mechanisms for doing it, though, need to be ones that are not discriminatory, not singling out a cohort as somehow more evil than others, and in a way that is profoundly discriminatory and is against our international promises.
Melissa Code.
2 questions. First, I'd love to draw your comments on how inelegant it is under our current system to rely so heavily on royal commissions to look at retrospectively what went so wrong. It seems to be every year we have another 2 royal commissions announced looking at something potentially egregious, and then the details of it comes out. And then secondly, I'd love you to speak to why, even though state-based charters can change people's lives in simple and profound ways, why it is that it's important we have a national instrument or variation of that.
The Royal Commission's question. What we saw with the Royal Commissions was people being left down, people being let down. And what they show was something that we spoke about a lot in our Free and Equal conference. A theme that was going across all of the sessions was how easy it is for people to become invisible, how easy it is for people just to lose a voice, not have a voice, lose a voice, or just being invisible. And where we see that playing out, the flip side of that is complacency. Everything's fine. We give a fair go. We're rights-minded. Of course, we're fair. We're nice. Everyone gets a fair go. But what about the people we are not seeing? That was the thing that came out in our conference. And out of that also came, well, what if you don't see them? What if you don't see them until the evidence starts piling up? So a lot of people who were otherwise invisible somehow becomes a mountain of compelling pain. Then we end up in a Royal Commission. Now, you asked, just the other part of your question.
Charters and why it's important to have an...
Oh, yes, the national one. Well, look at those Royal Commissions. Aged care, federal responsibility, disability, federal responsibility, particularly through NDIS and other mechanisms, veterans, federal responsibility, social security, federal responsibility. Those issues can't be touched by state and territory human rights acts. We need a Human Rights Act at the national level to complement those at state level and cover those areas of national responsibility for which our national government, our Commonwealth Parliament, is responsible for under our Constitution.
You mentioned at the beginning of your remarks the sorts of issues that have been raised over your tenure, and that you, as you conclude your term, the war in Gaza is inflaming tensions across the country and having terrible impacts on a range of communities here. How would a Human Rights Act change our community discussion about such things?
It would place, well, it provides the bedrock of building that understanding. It's not a magic weapon, but it provides the tools upon which those conversations can be grounded. And it provides that avenue towards not only respecting someone, and it was something I've spoken about recently, that human rights are about giving people dignity, free and equal in dignity and rights. And how do you make dignity real? For a start, you make it real by respecting. I've spoken of respect being the active voice of dignity, but more than that, and more than that now, that respect needs to be about empathy. If you don't feel and recognise the pain of the other, if you don't identify with the dreams and nightmares of the other, you can't open up that space of common humanity upon which the Universal Declaration of Human Rights and all of the other human rights instruments are grounded. You have to open up that space for the recognition of common humanity in which empathy can fill the space of social ruptures in our social fabric through which nasty stuff can otherwise flow.
And even without the Human Rights Act, what role can the Commission have in trying to help the conversations that need to be taking place in Australia now?
My Commissioner colleagues and I have spoken about the importance of our role. We are not one person's commission, we are the commission for everybody, for all the communities in our country. And that our job in having those challenging conversations is to hold the tension between communities at times, and particularly when communities in Australia have issues that bring them in tension with each other. Our responsibility, we are everybody's commission, and part of our responsibility is to take that longer view, have the open door, have the conversations, and hold that tension to help people navigate those challenging situations and find the way through.
Well, thank you so much for the body of work you've done as the leader of the Human Rights Commission. Thank you for your speech today, and good luck with the Human Rights Act.
Thank you.